I can't believe a teacher should never say that. I don't think
No,
so.
I
He,
agree. And
he,
people need sensitivity training. And there's been a lot of conversations recently I've seen on the internet about getting back to compassion, human empathy, and
yeah,
having to retrain people to start showing some empathy for others. No, high school teachers are not perfect. The ones that I had were not perfect.
no,
I
I
I
remember.
can't. Yeah.
Go ahead. I didn't want to be
No,
rude and
you.
take the word in.
No, no. Go for it.
I remember when we were growing up, when we went to school, our ears got pulled. We got hit by rulers. Yes, we did. And they had paddles, so they could be, they could be used on us when we did wrong. Or they would put us in the corner outside and all that. For real. I
I
just,
was I was blessed that I escaped that, but I know of other people in my family and other students that endured that. I was blessed that I was never spanked as a child at home or at school. I was just blessed because I kind of figured out from an early age if you do what's right, it's going to be a lot better for you. And I grew up in a
right.
military family, so I just realized, you know what? My dad's a sergeant in the Air Force, and sometimes he can be mean. So I realized if I do what's right, it's going to be a lot better for me. And in school, it was the same way. It's like if I do what's right, it's going to work out better for me. So I never got spanked, but they did do that though. In the schools I
Yeah,
attended, the paddling and all the detention,
yeah,
the ear pulling, I did have a teacher like in fourth or fifth grade kind of pull my hair once. And I told my mom didn't like it, but that was it. Yeah, she did. She kind of
yeah,
pulled my hair once. I was like, "Woman,
yeah.
nowadays that's assault and battery."
We're talking about my mom. I remember my mom going to the high school one day, excuse me, we were playing volleyball and I spoke up because there was a young girl that they wouldn't play, and I end up getting removing myself from the court to allow her to play. And then the coach got very upset at me when we were in halftime. She was yelling at me, and my mom heard that. So my mom gets off the bleachers, go all the way down to our dressing room, and she tells her that she doesn't have no right yelling at me because she's not my mom. And if she had a problem with what I did, she should have waited until we were alone, not to escalate in front of everyone that was there the at the gym. She told her,
Yes, good.
and
It's important for parents to stand up for their kids. Absolutely.
yeah, like I tell my daughter, I they email thank God for technology because they email me every day her progress or how she's doing because I asked them to tell me or to email me just to see what she's doing so I could help her out. And when I went in to talk to the principal and the teachers because there was an incident that they were bullying my nephew, and my nephew removed himself from the room, and my daughter saw him crying, so she approached him and he told her that the situation what had happened. So my daughter gets upset and angry because she sees him crying, all that. What she did wrong, she should have knocked instead of barging in someone's classroom, because she didn't knock. She just opened the door and started telling the teacher that's the way he runs the classroom, by allowing other kids to bully him. So they give us a call, so we go down there to see what's going on. And there's two sides to every story, you understand? And I said to myself, well, I'm gonna first listen to see what's going on, and then I'll ask questions. And then we asked my nephew, since he's the one that told her, and then he stated that they were making fun of him because he had farted. And the teacher, what he did is he got the fan and put it toward him. The teacher himself turned on the fan and put it toward him. And then he said that the reason that they were laughing because my nephew stated, oops, I ate some burritos last night. But then I told the teacher, well, if y'all were already making fun of him, he was trying to. What I say that he goes, well, since they're making fun of me, let me make a joke so I could feel better. So that's what he did, so he could feel good, so he wouldn't feel embarrassed. So he went ahead and said, oh, I ate burritos last night. Please excuse me. the teacher should have known better that, excuse me, when someone has an embarrassing moment and they're laughing at him and he's just there, you're going to say something so you can make yourself feel better. As
Yeah,
we,
rather than blowing the situation up, it's easier to go along with it, to fit
right.
in, to smooth everything over. Yeah. I mean, it really is, it's tragic what goes on in public schools or just in high school and all that in general. There are a lot of people that are definitely imperfect. They're human beings, they're flawed. And I definitely think you're doing the right thing as a parent and just being involved. I think that's the best thing you can do, Yolanda.
Yeah. Because nowadays we need to. We don't want our children to go the wrong way, as
No.
like I tell my daughter, when you turn 18, I don't longer have, like you say, control or whatever. But if you're underneath my rules of my home and guidelines, you're going to obey it. I'll respect you, but at the same time, you're going to obey my rules and guidelines that I have here. And I go, if not, you see those doors right there? Don't allow those doors to hit you behind, but you're always welcome back because I love you. But yes, I did tell it.
That's great. Okay, well, thanks for chatting with me, Alana. It looks like
Not a
we
problem.
have 6 o'clock Central Standard Time, and it's 4:01 here on the West Coast. Welcome, Adrian and Katie. Any questions before we get started? Module 3 is all about the attorney-client privilege, and it's really interesting stuff. Very important ethical guidelines and ethical rules that are going to be essential for you to understand as paralegals and legal assistants. Let's get started. So, for most concepts, there is an ABA model rule that provides a guideline that determines the correct professional conduct. And for the attorney-client privilege, it is Model Rule 1.6. We talked about it last week. It states a lawyer, paralegal shall not reveal information relating to the representation of a client unless the client gives informed consent. The disclosure is impliedly authorized in order to carry out the representation, or the disclosure is permitted by the next section, paragraph B. Then there's a comment that says the attorney-client privilege and the work product doctrine apply in judicial and other proceedings in which a lawyer may be called as a witness or otherwise required to produce evidence concerning a client. These rules apply to paralegals as well. So let me just give you an example. This is a textbook example based on a true case out of New York. There was an attorney who was representing a client in a murder case, and the client approached his attorneys and said, look, um, you know, there may be some other murders that I know about as well, because he had also committed those murders. And he says, I'll show you the bodies about these other uncharged, unsolved murders. So his attorney was like, whoa, okay. We're representing you for murder A, but the client is telling me that there's been murders B through Z and that no one's even found these bodies. But, the client's going to show us the bodies. So his lawyers grab their cameras and say, all right. So they go to this place in the woods. And sure enough, their client points to them where some bodies are. And the attorneys take pictures of the bodies. So the question is, Adrian, what do the attorneys do next? Their client has shown them where some dead bodies are, and presumably these are murders that have been committed. And what should the attorney do with that information?
I think the attorney has an obligation to give the evidence over to the court, and I don't know about the opposing attorney, but I mean, isn't that part of, you can give up confidential information if you're given the permission from the client, and then the others say if there's going to be bodily harm, or although he's already done it, so that's kind of throws a wrench in there.
It does. He's
Oh,
already done it. And the
yeah,
client is not giving his consent. He just is telling his attorneys, hey,
yeah,
you guys are
okay.
my lawyers. Let me show you some bodies I know about.
Excuse
Oh,
Excuse me, but the lawyer also calls a code of conduct he has to follow by too. Don't he has to report it to the police officer, regardless that his client did it or not?
No, because of
No,
ABA model rule, Yolanda. ABA
that's right.
model rule. A lawyer shall not reveal information relating to the representation of a client. Period. That is how strong the attorney-client privilege is. And the attorney-client privilege would apply in court if the attorney was asked a question about the bodies. That's covered by the attorney-client privilege. If that information is, if they ask for the attorneys took pictures of the bodies, this is a real case. The attorneys took pictures of the bodies. Those pictures are protected by the work product doctrine. No, that shows you how strong the model rule 1.6 is. So in this situation, no, the attorneys cannot tell the authorities.
Can
They
I say
can't.
something really quick? When you
Yep.
asked me that, I was thinking about it, and then as I was talking out loud, I was like, "Oh yeah, he already did this." It's not like because it goes on to say if he knows that there's a financial ruin or bodily harm or something. But yeah, so that was a little tricky, but yeah, okay. Just
It is. It's the bizarrest case ever. And I've posted a video in the online classroom and in the announcements where you can see the case discussed in detail because it's a real case that occurred in New York. And I can assure you, the family members of those, young women whose bodies were found were not happy with the lawyers because the lawyers were not forthcoming with that information because it was protected by the attorney-client privilege. So that just shows you the attorney-client privilege is a very strong privilege. Let's talk more about it. So here we have one of these informal ethics and disciplinary questions. So how we get one of these ethical disciplinary opinions is that a paralegal called an ethics hotline and asked a question. And the question is, what are the general ethical duties of a paralegal when you're communicating via social media? So, and the question again is, what are the ethical implications of a paralegal sharing or commenting on a social media post which promotes the services of an attorney? Is it permissible to recommend an attorney's services? May a paralegal provide an endorsement of a skill for an attorney on social media such as LinkedIn? So now we're talking a little bit more about the technology, how the attorney-client privilege would apply when you're using the internet. So here's the holding, the paralegal's duty on social media. Social media profiles used for personal purposes to maintain relationships with friends and family may not be subject to the rules of professional conduct, but when using profiles relating to advertising and soliciting, paralegals must remain aware that any information shared via social media might be seen by clients, attorneys, judicial staff, and others. Such information is likely to be subject to the ethical rules. Paralegals may post and accept reviews and must screen each review for accuracy. Paralegals may comment or respond to reviews or endorsements. Paralegals may solicit reviews and endorsements only as to known skills. Paralegals may endorse attorneys or other paralegals who are known to them on social networking websites. So any questions about this? Great. And this is also discussed in your reading. So for LinkedIn profiles and endorsements, the ethical rules place the burden on the attorney to monitor his or her social media content and correct or remove any entries that may violate the attorney-client privilege. So if someone was to post a comment in an attorney's website that can be seen by the public that may violate the attorney-client privilege, that information should be deleted. A paralegal with personal knowledge of an attorney's skill set may be able to provide legitimate and accurate endorsements. The prevailing wisdom is that the endorsement feature in LinkedIn should be turned off, hidden, or the categories limited, eliminating the problem. Does anyone use this LinkedIn profile or these endorsements? Have you ever seen this?
yes, I have, but I don't use them.
Okay. And that's really the recommended approach, is not to use them too much. let's get back to the attorney-client privilege. So the attorney-client privilege and its scope. So the attorney-client privilege applies to a confidential communication between a lawyer and a client made for the purpose of seeking, obtaining, or providing legal advice. So this is the test. This is the test for determining whether a communication is protected by the attorney-client privilege. So getting back to our case of New York, all of the murders. So the client, suspect, murderer, tells his attorneys he knows where some bodies are. That is made for the purpose of seeking, obtaining, or providing legal advice. That's within the scope of the attorney-client privilege. It is a communication made between lawyers and clients. So it's covered by the attorney-client privilege, which means the attorney cannot disclose that information. And now, let's talk about something that an attorney may learn about a client that would not be covered. And this happens a lot in personal injury law firms. So you always see these advertisements on the TV about personal injury lawyers. You know, if you've been hurt, call this number. Has anyone ever seen that commercial? If you've been hurt by a product or in a car accident, call this number. Okay, Adrian says yes. Yeah, here in Nevada, it's day and night. If you have used this baby powder, if you have taken this pill, if you have, you have been an AT&T customer, it's like, if you've done any of this stuff, call a lawyer and get your compensation. So suppose that someone did that. Okay, they were in a car accident. A client calls an attorney. The attorney takes on the case for the client who's been in a car accident, and the client, says, look, right now I've got whiplash and I'm in bed and I'm suffering all these injuries as a result of my car accident. Well, the next week, the attorney decides to go skiing. And what does he see? He sees his client on the slopes. No neck brace, no whiplash, and the guy's taking on the turkey run or one of these really, really risky, steep slopes. Can the attorney then call the insurance company and report this client? What would you do in that situation, Adrian?
You know what? I don't know. I'm afraid to answer incorrectly, but I mean, clearly he knows he's lying, but he's already taken him on as a client. So I guess you have to kind of continue forward and try to get him to admit he's lying. I don't.
Okay, well, that that moment where the attorney sees the client, and this has also happened for other personal injury plaintiffs who private investigators sometimes are hired to watch these people, and the private investigator sees them mowing their lawn, they're out hoeing, they're gardening, they're digging up roots, and they're like, oh, well, I thought they were injured really bad and in bed with whiplash, and they're supposed to be in a neck brace, and they're outside doing yard work, and then they're jumping in the swimming pool. So that's not a communication. So it's not covered by the attorney-client privilege. The attorney-client privilege only applies to a confidential communication, Adrian. So in that instance, if the client is trying to defraud an insurance company by claiming that they suffered personal injuries and they didn't, then the attorney can report that information.
I have a question about that then.
Yep.
I thought the attorney-client privilege also, like the scope of it was not just what they're told, but like if they find out other things, like I thought that was true, but okay, maybe I read that wrong.
There's two different things.
Oh,
There is the duty of confidentiality
that's what I'm
that we
thinking of.
talked about
Okay,
last week. That is broader than the attorney-client privilege. The attorney-client privilege is more narrow. For example, the attorney-client privilege only begins once the attorney undertakes the representation of a client. It applies only to communications. The duty of confidentiality should be considered as a separate thing that applies to anything that an attorney or paralegal learns about a client before, after, or during representation, and it's not limited to communications. So you want to keep those two concepts separate. Everything that would be covered by the attorney-client privilege is covered by the duty of confidentiality, but everything that's covered by the duty of confidentiality is not covered by the attorney-client privilege. The attorney-client privilege is very narrow. It's very narrow in scope. It applies to a confidential communication between a lawyer and a client once the lawyer has already undertaken the representation of the client, made specifically for the purpose of seeking, obtaining, or providing legal advice. So you seeing a client out on the slope skiing is not a confidential communication, is it? And so that's why the attorney-client privilege would not cover that information. So if for some reason the attorney was asked to testify in court in an insurance fraud case, and the judge asked the attorney, or somebody else in the court asked the attorney, did you ever see this plaintiff walking around without his neck brace on? Did you see him in his pool swimming during the period that he claimed that he was disabled? And the attorney would have to say, yeah, I saw him on the slopes. Then I saw him at home gardening. And then I saw him jump into the swimming pool and on the deep end. Um, so that information would not be covered by the attorney-client privilege because it's not a confidential communication. Whereas in the first case, in the New York case, the client came to the attorneys and said, I know where some dead bodies are, and I'd like to show you that. And that was a confidential communication between a lawyer and a client made for the purpose of seeking, obtaining, or providing legal advice. So that would be protected by the attorney-client privilege. Any questions? So anything, Katie, covered by the attorney-client privilege cannot be disclosed. The information that is not covered can be disclosed. Did that answer your question, Katie? Okay, so let's talk more. An attorney has a duty to disclose a fraud on the court, probably insurance fraud, certainly a fraud on the court. So if the court believes that this client is injured and they're really not, then the attorney would have an obligation to disclose that. And we're going to talk more about that distinction between being able to tell and having a duty to tell. So we'll talk more about that. So the scope of the attorney-client privilege belongs to the client to prevent the attorney from disclosing matters they have discussed. The attorney is prevented from testifying about matters protected by the attorney-client privilege and can't tell the police either, such as the dead bodies in the woods. The attorneys cannot tell the police that they found these other young women who were missing. Sadly, these kind of crimes have been going on for years and years and years, especially if you watch forensic files, all real cases about things that have been done to these young women by creepy predators. And many of these people are serial killers, serial rapists. When this happens, it's not just that there's a bunch of people out there raping and killing. It's one or two people and they're serial, and they continue to do it until they're caught and put in prison for the rest of their lives. So that's why in the New York case, the man knows about all these other dead bodies. He's probably a serial killer, serial rapist, and that's why he's been doing it for years and leaving the bodies in the woods. And the police have only been able to find one body and charge this guy with one murder. But he's probably committed 10, 15, 20, because he's serial. Same people keep doing it over and over again until they're caught and put in prison for the rest of their lives. So anyway, in that situation, the attorney is prevented from testifying about matters protected by the attorney-client privilege, and that cannot tell the police either. Wouldn't the police love to know where these missing women are? Wouldn't they love to know that? Wouldn't the families like to give their dearly departed a proper burial? But the attorney can't tell that information. The attorney can't share it. Cannot. Not able to. unless the client waives the privilege by disclosing the information to another person or by making the affirmative decision to waive the privilege. And so what ended up actually happening in the New York case is the client started feeling guilty, and he talked to his attorneys and said, you know what, let's do a plea bargain. Let's offer to tell the prosecutor about the other dead bodies in exchange for our client getting a very a very weak sentence. And then, is that ethical? I mean, does that benefit the good of society to have a serial murderer get a low sentence because he can make a deal? He can plea bargain using these other unknown bodies in the location of that and tell the prosecutor, I'll show you where some more bodies are. If you give my client a really good plea bargain, cases are plea bargained 99% of the time, just to get, things moving through the criminal justice system, making it easier. So that's how that case ended. And again, I posted a video in the course announcement so you can see exactly what happened in that New York case. So you'll be writing about the attorney-client privilege and the work product doctrine in your Module 3 assignment. Fortunately, though, your assignment is a civil matter, not criminal. Okay, so the next privilege we need to talk about is the work product doctrine. The work product doctrine is just that. It's intended to prevent disclosure of the attorney's work product. So, when I was practicing law, I would sit in my office and I would think about the case and I would write notes down on a notepad. We didn't use computers back then. We wrote things on a notepad. So I would think about different approaches in the case. I would think about who did what, and, how we're going to approach this case, what we're going to do next, the witnesses I need to interview, the evidence I need to obtain, that kind of stuff. So that stuff is also protected from disclosure. Case strategies are all part of the work product doctrine. There's two different types of work product: factual work product, and then the attorney's mental impression. And I would write that down, who I thought was really guilty, or who I thought was responsible for a car accident, or who I thought breached a contract, whatever. I would write that stuff down and make a note of it. And, the next day, maybe, interview a witness, something like that. That's attorney work product. It's also protected from disclosure. The work product doctrine protects materials created by or for an attorney for the purpose of litigation. This might include information you ask your client to assemble for you, like a timeline of events. If it's a personal injury case and you want your client to say, okay, what do you remember it happened that night of the car accident? Where were you? What lane were you in? How fast were you going? Did you get injured? Did you get taken to the hospital? What injuries did you have? Did they x-ray? Whatever. Timelines or research prepared by a paralegal. If the attorney, goes to the paralegal and says, I need you to look up the personal injury law involving SUVs that roll over in Minnesota. Can you get on Lexus Advance and do that research for me? That would be work product. Legal research memoranda prepared by a law clerk, an interoffice memo if two attorneys are talking about strategy in a case. So all of that stuff is protected by the work product doctrine, because you can see how it would undermine your case if the other side could find that out, right? If opposing counsel can get all of your notes, your mental impressions, and all of your research, that would undermine your case totally. So no, that's protected by the work product doctrine. When can that information be discovered by the other side, which is what your Module 3 assignment is about? Well, we're looking at Federal Rule of Civil Procedure 26, which is the discovery rule in federal court. There is no other except for Federal Rule of Civil Procedure 26. It is the discovery rule. It says when an attorney's work product may be discovered. Ordinarily, a party may not discover documents, intangible things that are prepared in anticipation of litigation or for trial or for other party or its attorneys, but subject to Rule 26B, 4, those materials may be discovered if they are otherwise discoverable, and here is the exception when you can disclose the work product. If the other party shows it has a substantial need for the materials to prepare its case and it cannot, without undue hardship, obtain their substantial equivalent by other means, if a court orders discovery of those materials, it must protect against disclosure of the mental impressions, conclusions, opinions, or legal theories of a party's attorney or other representative concerning the litigation. So, undue hardship. If you are representing the driver that's being sued in a personal injury case, and you want all of the stuff that I've prepared in my representation of the plaintiff, you're going to have to go to the court and show undue hardship. You have no other means of getting that information. And the court is still going to have to review those materials and protect against the disclosure of any mental impressions or conclusions, opinions, or legal theories. So this would be the rule that you'll be discussing in your Module 3 assignment. Let's talk about that assignment. It's a response to a discovery motion. The purpose of this assignment is to be able to explain privileged communication and work product and demonstrate real-world application of each privilege. You're a paralegal who has been working on a case closely with your attorney. During discovery in the case, the opposing counsel requested copies of communications between you and the client, as well as copies of the timeline of events you've prepared while reviewing the case file. Your attorney believes that the documents are privileged and refuses to turn them over, but the opposing side files a motion to compel discovery or asking the court for an order directing you to disclose the documents. So your job is to prevent these documents from being disclosed by preparing a response to the motion to compel. So you want to use the format found in the opposition to motion template. I'll show you what that looks like. I'll show you what an opposition to a motion to compel looks like. You want to research the issues of privileged communications, prepare the response. Your response should address the issue of the privileged communications between yourself and the client, as well as the issue of whether the timeline prepared by the paralegal is protected work product. Your response must include case law, statutes, and rules. Case law, statutes, and rules are primary legal authorities. They're binding on us, and they're what we need to be discussing in these motions in our responses. Primary legal authorities, case law, statutes, and rules. Format. Use the attached motion template. Include case law, statutes, and rules to support your arguments against disclosure of the requested documents. Be sure to employ proper spelling and grammar. Format your references in the proper Blue Book format. You need to use Microsoft Word, Lexis Advance, or Fastcase. We're going to look at the grading rubric. And of course, this assignment's due Sunday at midnight Central Standard Time. So one thing I would encourage all of you to do is to really get to learn Lexis Advance. You're going to be using that as practitioners, so you should learn how to use it. And right now, the Justice Studies Department is encouraging you to meet with a librarian and just make an appointment. It's probably like 45 minutes, and they will show you how to use Lexis Advance. I did this when I was in college. I did it again when I was in law school. I did it again when I was an attorney. You need to know how to use Lexis Advance, again, as a practitioner, as a legal assistant, as a law clerk, as a paralegal. You will be using computer-assisted legal research. So you may as well take the time now to learn how to use Lexis Advanced. Believe me, I still don't know all of the features. So go ahead and, make this research appointment before you write your memo. Let me see if I can pull up a sample memo that another student wrote. Share content. Find a file, if I can, that shows an example of this assignment that was written by another student. This would be legal memo template. Module 3 model assignment. There it is. Woo, there it is. Woo, there it is. I'm going to stop my video just for a moment because it's using up too much bandwidth. Let's take a look at this sample module 3 opposition to a motion to compel discovery. This was prepared by a student. There your facts are. You want to make sure you follow this template because you're preparing this as if you would submit this to court. This is the standard caption for a memorandum that will be submitted to court. United States District Court. Whenever you see United States District Court, that's the court of the United States. That is the federal district court. There is one or more federal district courts in every state, not to be confused with the state court system, which is totally different. So this is the federal court, which is located in every state, deciding things under federal law. There's the name of the case, Hightower versus Shorty's window washer. And hi, Megan. We're taking a look at the Module 3 assignment. So here's the introduction, which is provided to you, the facts we discussed. Request for production seeks documents evidencing correspondence between plaintiff, third party pertaining to the instant litigation, seeking notes, timelines, calendars, prepared by plaintiffs. Defendant filed a motion to compel, seeking production of those documents. But we're going to argue that each requested document is protected from disclosure under the attorney-client privilege in the work product doctrine. So this student started their paper with the federal rules, which would apply in federal court. Federal Rule of Civil Procedure 37 gives this court broad discretion to grant relief in a motion of compelled discovery. But in this case, there is no need to compel discovery because each document is protected from disclosure under the attorney-client privilege. So the assignment gives you several questions to answer. One of them is whether or not the attorney-client privilege extends to paralegals. And you want to cite, the law in your state, for example, do some research on Lexis Advanced to pull up the appropriate statute. B, correspondence between paralegal and the undersigned paralegal is protected by the attorney-client privilege. The next section of your assignment will be C, the work product doctrine extends to attorneys' agents, such as paralegals, and D, the timeline prepared is protected by the work product doctrine. So that wasn't bad. Okay, any questions on how to do that Module 3 assignment? Let me share my web browser with you, and we are going to go into the online classroom and make sure that all of the links are working. And we're going to look at the grading rubric for the assignment. Here we go. I've got a web browser here. There's Blackboard Learn. Logging in. Password. I better enter the right one. Looks like I did. We're going to take a look at the grading rubric, so just so that you understand what the expectation is for this assignment. so that you can see where your points are coming from and, get the maximum points. So we're in module 3. Excuse me, we're looking at this. There we go. See if I can get all this. Here we go. Written assignment, response to emotion. I don't really need all the other stuff highlighted. Cool, cool, cool. Grading rubric. There we go. So this is how your module 3 motion will be graded, response to motion. So there's no secrets. Everything is being disclosed where your points will come from. I use this grading rubric when I grade. Research and use of sources for privileged communication and work product. I believe it's asking for 3 primary sources. Aligns with goals. Have you analyzed the privileged communication issue? Advanced analysis of case law, which directly explains why the disclosure of the timeline is not permitted. Analysis of the work product issue. Advanced analysis of case law presented, which directly explains why disclosure of the timeline is not permitted. Mechanics. Always run Microsoft Word editor to check your spelling and grammar. If a word is highlighted in red or blue, that means you have a misspelled word or grammatical error. So this is where your points are coming from, and you can always, look at this rubric yourself. And let's take a look at the assignment itself and the links that are provided here. There's your template. See if I can open this template. Download original file. So you can work from this template and simply fill in the information. So be sure to use this template to prepare your module 3 opposition motion, because it's going to have the information that you need in there and spaces for you to fill in the information that you need to fill in. So what
I
you'll
have a question, Professor Dove.
Yeah.
For the template, are we rewriting the whole thing, or are we just putting in where it says to insert, from the questions? Are we just doing that part? Does that make
Let me
sense?
see if I can open it. There it is. Can you see this?
I don't see it.
Alrighty. I just downloaded the document, and all you're going to do is there's portions highlighted in yellow, and you will simply be filling out the information. So I'm going to save the template on my computer, and then I'm going to open it up for you, and we'll take a look at it. Save as module 3 motion to compel template.
I just want to make sure you don't want us to rewrite like the whole thing. Just insert where
No.
you're asking us to insert our citations and our statutes and the reason why.
No, never reinvent the wheel. So I'm going to open up the
Good.
template, start with the template. And I just downloaded the template myself. So that's what you're going to start with. Let me open up the template, share a file, desktop, module 3. It had a long name too. Just downloaded it. There it is. Opposition motion. Sharing. Okay, so this is a template that you've been provided, and the introduction is there for you. First page is done. There you go. So only the portions highlighted in yellow do you need to insert your research and your analysis. So first you'll do the research. You'll find out which rules and which cases you'd like to discuss. And you'll add it right here where it's highlighted in yellow. So you'll be filling in information under A, B, C, and D. So that helps. You've already got your caption. You got the first page, and you just enter information for pages 2 and 3. And, be sure to proofread Try to be concise. Try to get to the point. Be sure to cite the applicable rules. Federal Rule of Civil Procedure 26 and ABA Model Rule 1.6, things like that. Any questions? So this will be a great assignment because it's very, very realistic to the type of work that a paralegal does. Again, if you're already an expert at doing computer assisted research and you already know how to use Lexis Advance and Fastcase, great. If you don't, just make a library research appointment. And that takes us to the end of our Module 3 live session. The live session question for this week is, when is an attorney's work product discoverable? And that information is in Federal Rule of Civil Procedure 26. Again, if you ever run into any tech-related issues, please call personal support. They're available 24/7. Problems submitting an assignment, problems with your computer crashing, problems, with Blackboard or a link not working, they're great for all of that. And just be sure to, submit your answer to the live session question by Sunday and submit your Module 3 written assignment by Sunday. Any questions for me? Perfect. Thank you so much. There's no discussion forum for this week, so no quiz either. Just these 2 assignments. Thank you, Adrian, for attending. Thank you, Yolanda, Katie, and Megan. If you have any questions, feel free to reach out, send me an email. I'm always available for you. Have a great week.
Same to you.
Thanks, Yolanda. Bye.
Bye.